The problems in the US patent market are well documented. Liquidity and values have fallen in the first quarter of 2016 to their lowest levels in 7 years. And it's no wonder that the people in the industry gathered here in Barcelona at IPBC Global are wondering not just how it all began, but where it's all going and how we're going to find new ways of restoring the US patent market to its global leadership. I put that question to the former Undersecretary of Commerce for Intellectual Property and former Director of the US Patent and Trademark Office, David Kappos. To what extent were the problems of today already visible during your time there?
Well, during my time in the PTO, we were focused on getting the America Invents Act through and then implementing it. And the America Invents Act, in turn, was in large measure about two things. One, moving the US to global standards for patenting, and that was a good thing. And then the second thing, correcting opportunities for abuse in the US system, and that was a good thing to do also. So I would say the problems that were evident at the time I was in the government have now largely been corrected, and the issue now is, did we overcorrect, and if we did any more in the US, would we then be clearly overcorrecting?
You're leaving those questions rhetorical. Let me ask you then, did you overreact at those times, or was the act an overreaction?
So I think that, as is always the case when you make lots of changes, you don't get everything right. So I would say that we did probably a little too good of a job in some ways of correcting for the perceived abuses, and that some tactical modification is now needed to bring back to the center line the overcorrections that we now know that flowed from the AIA. I do think there's significant risk of really substantially overcorrecting at this point if any more major legislation or more major court decisions were to be put through in the US.
Where do you see the biggest danger if this issue was to be tackled again?
Well, in the US, of course, there's been legislation pending in the House, so-called H.R. 9, that would, in my estimation, and I think pretty clearly now represent a dramatic overcorrection that would badly damage the US patent system. So it would include things like a so-called covered customer stay provision that I strongly believe is just not needed in the US. Existing law handles that problem. It would include mandatory fee shifting of attorneys' fees. Well, we had 2 Supreme Court decisions in the US that have caused a tripling, not just 10% more, but 3 times more requests for shifting of fees, and about a 2 times actual award of shifting of fees. So dramatic change from Supreme Court decisions. We don't need legislation now that just redundantly fixes a problem the Supreme Court's already fixed and actually causes more litigation, which is what would be the result of that legislation. So there's a whole series, there's rigid portions of H.R. 9 that would deprive judges with their ability to exercise judgment, which is the fundamental role of judges. And I think all of those parts of the legislation, in fact, that whole legislative package has just been completely overcome by events, the AIA taking effect and becoming so effective, as I said, maybe too effective, Supreme Court decisions, Federal Circuit decisions, the Federal Judicial Conference, which made its own set of changes. If you add all of that up, there's absolutely no need for H.R. 9 anymore.
So who's driving it and why?
It's like anything else. It gains a head of steam. It's legislation that's been around for a while. It takes a while for it to become evident to members of Congress and to the apparatus there and the staff that the underlying facts have really changed a lot. And so what may have been something that needed to be discussed at the time no longer is. So it's a byproduct of the timing and the era in which the legislation was introduced, versus the now 4 or 5 years of facts that have accumulated that now show that it's not needed.
And if you were still Undersecretary of Commerce, would you advise the President not to sign it?
Oh, absolutely. Yeah, I'd be saying we need to work with Congress and set a new agenda here, because we've clearly corrected the abuses that need to be corrected in the U.S. system. And if anything, some tactical fixes are needed to deal with overcorrection. But we certainly don't need more massive patent reform in the U.S.
Actually, why did you resign the position when all these things were on the table?
Well, we had completed a lot of things, including implementation of the AIA. I stayed in the government a long time by U.S. presidential appointed standards, about double the normal tenure of people in those positions. And I felt like it was time to let some new blood come in and let someone new, bring in a new agenda, and time for me to move back into the private sector.